China just passed its Personal Information Protection Law on August 20th. Will this law govern the data processing activities of multinational companies?
Well, the first step is to check whether the company's subsidiaries and affiliates are located or incorporated in China. So long as these entities process personal data, they must comply with the Chinese law. If you don't have a setup in China, then the second step is to confirm whether the company is collecting and analyzing personal data originally generated in China. If yes, then it is necessary for your company to launch a compliance program for the Chinese Personal Information Protection Law. This is indeed similar to the situation of the GDPR compliance.
I see. So, for the companies who already invested into the compliance of the GDPR, will the Chinese law require additional measures?
Yes, there are additional measures to be taken. The first thing is to review definitions of your company's existing policies and privacy notices. Although the Chinese law borrowed concepts from international norms, such as the right to delete, the right to access, and the so-called portability right, the Chinese law remains certain significant conceptual difference from the GDPR. For example, under the Chinese law, there's no such a term of data controller. Instead, the law uses the term data processor to refer to all entities who collect and process the data for their own purposes or for other people's purposes. Namely, if your privacy policy was drafted on the basis of the GDPR division between data controller and data processor, we would have to review these policies and make necessary changes or even restructuring of the whole policy.
Sure, I know that the term data processor under the GDPR refers to those entities who are engaged by the actual data collector. However, data processor under the Chinese law will be both the data controller and the data processor. We really need to adjust our policies.
That's true. Another key issue would be the cross-border data transfer. The Chinese law takes a threefold measure to control the data transfer outside of China. Firstly, from the individual's perspective, you must receive an informed consent from each individual data subject. Secondly, you must receive the government assessment or authority before you can transfer the data outside of China. Or, as an alternative, you may sign a data transfer agreement that is strictly following the model contract that will be published by the authority. Thirdly, the authority will maintain a blacklist which lists out the companies that is considered to be endangering national security, public security, or individual rights.
Does it mean that even if we receive an informed consent from the data subject, we still could be prohibited from transferring data out of China?
Yes, there will be a certification requirement, as I just mentioned, or maybe you can use a standard contract that is published by the government. While the detailed procedure remains to be clarified by the authorities, we are developing such capability to assist our clients working with government agencies to secure such kind of a certification, assessment, or the standard contract.
Is there a requirement to companies to appoint data protection officers?
For companies incorporated in China, they will need to appoint a data protection officer only when they process a large amount of data. However, for foreign companies processing personal data originally from China, they must either setting up an organization in China or appointing a representative in China, particularly managing the data protection issues. The name and the contact information of the representatives shall be reported to the authority.
Okay, then what would be the punishment to violation of the law?
The law extends the punishments to both entities of the data collector and their officers. A company may be fined up to 50 million renminbi, which is roughly equal to 9 million US dollars, or about 5% of its annual revenue. The entity's individual officers may also face up a fine up to 1 million renminbi, which is roughly equal to 160,000 US dollars. Also, the officers who are fined violating the law may be further banned to take certain positions, such as directors, data protection officers, or other high-level managers. Finally, the law grants the authority of the data protection a power to so-called suggest the business registration authorities to cancel the violator's entity's business license.
That sounds harsh. Is there a room for companies to correct their privacy practice before they are fined?
The law does offer a chance of correction. Namely, a violator will be normally required to correct their illegal activities first before receiving a fine ticket. However, during the period of the correction, the violator's business might be required to suspend it. And if you are collecting personal data through a mobile application, your application might be taken down during the period of correction. One more thing I wish to highlight is that the Personal Information Protection Law is just one aspect of the Chinese government's overall effort of administrating data process. So companies should plan their data strategy in a larger picture. The good news is that the Chinese law does accept the universal norms of personal data protection, which means a company's prior efforts in compliance with GDPR will largely be helpful for the company's business and compliance work in China.
Email us if you have any questions. Thanks for watching.